Right, who's next, Mr. Manning?
Judge, next we have Mr. Charles Brown.
Charles Timothy Brown. Cause numbers CR 25-64 and 65. Mr. Brown, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. Your name is Charles Timothy Brown, correct?
Yes, sir.
And Mr. Brown, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work that he's done as your attorney?
Yes, sir.
You understand everything that you've read and signed as part of your plea agreement?
Yes, sir.
All right, Mr. Brown, you've been charged with a state jail felony offense of burglary of a building that does carry a range of punishment of not less than 6 months in prison up to a maximum 2 years in prison, that being a state jail prison, and a possible fine not to exceed $10,000. I see that there is a plea agreement in your case wherein upon you pleading guilty to that charge, the state's recommended to the court that the court consider the evidence, not convict you, place you on deferred community supervision for a period of 3 years, along with a $2,000 fine, plus court costs of $290 and reimbursement fees of $535. And it appears that the state is recommending that the court dismiss your other indicted costs, CR 2565, which is an engaging organized criminal activity, be dismissed pursuant to section 1245 of the Texas Penal Code. Is that your understanding of the plea agreement?
Yes, sir.
Mr. Manning, do you believe Mr. Brown to be competent to enter into this plea agreement today?
Do, Judge.
And you've explained to him his rights regarding the case and the advantages and disadvantages of a deferred adjudication plea?
I have.
All right, Mr. Brown, at this time, how do you plead to burglary of a building?
Yes.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
Court does accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the stipulation of evidence?
No objection as offered.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor. Thank you.
From the defense?
Rest on close, Judge.
All right, court will review the evidence. Mr. Hernandez, was there any claim for any restitution by the victim of this offense?
Your Honor, the property was recovered in Kaufman, both the currency and the box of cigarettes allegedly taken.
What about the broken glass on the front doors to the business?
We never received any additional information on that, Your Honor.
All right, court, having considered the evidence, will follow the plea agreement or hereby defers a finding of guilt on the offense of burglary of a building. Court places Mr. Brown on 3 years community supervision, orders him to pay a $2,000 fine, $290 in court costs, $535 in reimbursement fees. Court does dismiss under section 1245, cause number CR 2565. Mr. Brown, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted. After that, you'll meet with the probation officer. Who's next, Mr. Rainey?
Judge, I believe that concludes my business. May I be excused?
Yes, and I assume Mr. Windsor never appeared.
Judge, I have not been able to track him down at this point.
All right, the court will have the name Demetrius Windsor called loudly and distinctly 3 times in the courthouse. Failure to appear will result in issuance of a judgment nisi alias Capias. Mr. Offered,
Judge, I believe that concludes my business. May I be excused?
see you this afternoon.
Thank you, Judge.
All right, the court finding that Demetrius Windsor, having received notice of today's hearing for arraignment, has failed to appear as ordered. Name has been called loudly, distinctly 3 times in the courthouse with no response. Court hereby issues a judgment nisi and alias Capias and sets new bail in the amount of $100,000. This is cause number CR 25-101, State of Texas versus Vincent Offered. Mr. Offered, we're set for arraignment today and also on status of hiring an attorney. Have you hired an attorney?
Yes, sir, I did. With a misunderstanding, I give the person the money to, to pay the attorney for the payment, down payment. And she didn't, her card got declined, the credit card. That's what the problem was. As soon as I can get here, I can get to them, I have it all taken care of.
So you have the money or you don't have the money?
No, I have the money. I had gave the lady the money to, pay my attorney, for the credit card. Cause I had, set up a payment plan, pay for the lawyer. That's what it was. If I can get back to it, I can get it to him, I have attorney though.
So how much money did you give?
$2,500.
You gave a lady $2,500
Yes,
for her
yes.
to use her. Why didn't you just give the $2,500 directly to the attorney?
Well, because I'm working with, so much though. I'll get it handled though. No problem. I go get it taken care of.
So this lady is going to give you your $2,500?
Yeah, that's no problem. I have an attorney, but if I come back, you give me enough time to come back, I'll be back. I'll take care of it. I will
All
be
right,
back.
Mr. Offer, this is what we're going to do, okay? I'm going to reset you for August 12th.
That's next month.
That's next month.
Yes, sir.
But I'm going to order you to have the attorney paid within 10 days.
Yes, sir. I have the money. That's no problem.
So I expect to see a letter of representation from an attorney within 10
Yes, sir.
days.
No problem.
Okay, so
Yes,
that doesn't mean pay on the day before court.
No.
I mean, within 10 days, I want the attorney paid, whoever it is. I
Yes,
just
sir.
want a letter of rep saying that they represent you.
Yeah, I have them. Yes, sir.
And then have them back here in court with you on August 12th.
Yes, sir.
All right, I'm gonna have you sign a notice of appearance
Bye.
and you'll be free to go.
Thank you, sir. They'll contact y'all. Take care. Thank you.
That hearing had a little bit of everything. We opened with Charles Timothy Brown calm, polite, and ready to resolve his case. He pled guilty to a state jail felony for burglary of a building, but thanks to a plea agreement, the court deferred a finding of guilt and placed him on 3 years of community supervision. The deal also included a $2,000 fine, court costs, and reimbursement fees, while dismissing a second, more serious charge of engaging in organized criminal activity. Judge Martin took his time walking Mr. Brown through every piece of the agreement, making sure he understood his rights and confirmed this was voluntary. The judge even double-checked restitution, learning the stolen property, including cash. And a box of cigarettes had been recovered. That's a rare, clean ending in cases like this. It was a textbook plea hearing, with Mr. Brown coming across as respectful and fully cooperative. Then things got more animated. Enter Vincent Offered, scheduled for arraignment and supposed to have hired an attorney. What followed was a bit of a verbal maze. Mr. Offered explained that he gave $2,500 to a woman to pay the attorney via her credit card, but the card got declined. Why not just pay the attorney directly? That was unclear. The story was winding, but the core issue was simple. He had the money, allegedly, and needed a little more time. Judge Martin was visibly trying to stay patient while sorting through the confusion. Ultimately, he gave Mr. Offered a clear directive. Get your attorney paid and a letter of representation filed within 10 days. Not by next court date, not. Whenever it works out, 10 days. That was about as generous as it gets without letting the wheels fall off. Offered promised to handle it, and we'll see if he follows through. And just to tie it all up, we had Demetrius Windsor who didn't show up at all. His name was called 3 times in the courthouse, and with no response, the court issued a judgment nisi and an alias Capias warrant, setting his new bail at $100,000. That's a steep price for missing court, and a firm reminder that showing up matters. Judge Martin, once again, managed a diverse docket with equal parts firmness and flexibility. He allowed reasonable resets, enforced clear deadlines, and didn't hesitate to act when someone failed to appear. It's the kind of courtroom work that may not make headlines, but it keeps the justice system running. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one,